Delhi has various corridors of power, but over the past few years, APJ Abdul Kalam Road has seen several Bollywood celebrities to political bigwigs and businessmen in attendance. Why? Because APJ Abdul Kalam Road houses the Office of the Enforcement Directorate, or the ED, and ED, as we know, has become a household name, even a butt of some jokes and memes over the past few years. But no discussion on ED can ever be complete without talking about and a detailed discussion on the Prevention of Money Laundering Act 2002. Why am I telling you this? Because PMLA, Prevention of Money Laundering Act 2002, is the first law that we discuss in this new series that we are bringing to you, this new video series, in which we discuss the laws that shape India. We tell you more about these laws that give India the character that it has now. And for this first episode, you have me, of course, Apoorva Mandhani. You have Bhadra Sinha, who you've often seen on our YouTube channel. And we have former Delhi High Court judge and former chairman of the PMLA appellate tribunal, Justice Manmohan Singh, for you. Welcome to our show and YouTube channel, sir.
Thank you so much.
Bhadra, if you take it forward from here.
Yeah, so as Apoorva has pointed out, in this episode, we are going to talk about the Prevention of Money Laundering Act, which is in news for various reasons. And there can be nobody else better than Justice Manmohan Singh to elaborate and give us an insight into this law as to how this law came into being, why was it notified, what are the problems with it, and whether it needs any more changes or not. So, sir, first of all, my first question to you would be that why was this act actually introduced by the government of India, sir?
1989, United Nations noticed that there is some drug peddlers and drug mafia are indulged in the practice of spreading the drug where the national security is involved, and they basically have the joint meeting in Paris in 1989, and so that some law should be brought all over the world so that basically tainted money may not be used for drug purposes, and national security should also be secured. So there were discussion by many countries in United Nations. The first charge is taken by the Australia. Then India is also one of the party, and various meetings were attended till 1998. And there were so many discussion in Parliament to bring this law, money laundering. And ultimately, after so much discussion in 2002, the law was codified and this PMLA Act has come into force. Now, the purpose of this entire thing is that it has been noticed by the United Nations and various countries of the world that these offenders, economic offenders, they basically suppose some action is taken because trial is taking a lot of time. When the trial is over and they are convicted, they eat the money, they basically dispose of the money so that state will get nothing in their hand. So they say, why not basically some arrangement should be done that property should be attached so that if somebody is convicted, that property should come to the state, and there should be pressure upon the offenders also. So now then basically in Parliament it was also discussed that how basically we can proceed with. So if we read the PMLA, its object, as well as the Civil Procedure Code, that is Order 38 Rule 5, there is a provision that attachment before judgment. So some of the language was taken from that Order 38 Rule 5, and if we read Section 5 read with Section 8, you will find that it is almost gel with the Order 38 Rule 5 of Code of Civil Procedure. So this law was there, and at the initial stage, there are very few cases in PMLA, but now for the last 10 years or 15 years or maybe even recently for 2-3 years, there are large number of cases. I was appointed as the chairman between 16 to 19, and when I joined the office, there were about 2000 cases, 2100, 2000 to 2100. I was able to decide about 1200 cases, but gradually I felt that so many cases are being filed, so many acts are included under the PMLA, because some of the acts have been given to PMLA court, like Benami Act, like FEMA. FEMA was absolutely independent tribunal in Kasturba Gandhi Marg, but ultimately government decided that it should also come to the PMLA court. So this was the history of.
So over here, I would just like to ask you another question. Is when you just mentioned about these other laws like Benami Act and the FEMA law. So what is the relevance in the sense? Is it that PMLA proceedings can be initiated if only there is a scheduled offence committed by somebody? So if you could just briefly explain the procedure as to how the PMLA proceeding actually is initiated by the Enforcement Directorate.
Yes, I tell you, actually, when the original act came, everybody says it is a very innovative act, and purpose was also innovative, so that basically economic offender should be caught and they should be prosecuted as per law. That was a main purpose, rightly so. It is nobody's case that the person should not be prosecuted if somebody has violated the provision of PMLA or Benami. Everybody says, every citizen in this country says that if somebody is involved, he must be prosecuted. So then basically, when this act was discussed in Parliament, one of the issues, same issue, whatever raised by you about the schedule offence, I'm telling you, because schedule offence is a general law, that is Criminal Procedure Code. So then government says that why not basically we should add something. We should add something with the general law, so that basically property should be attached, forfeited by the state, and so that basically when the trial is over, the attached property should come to the government and the offender should suffer because of this. That was the thing. And there was a schedule in the PMLA Act that what are the offences which are schedule offences. So basically, there is a myth about the schedule offence or PMLA Act. If basically two things I will just say that if we see section 2U of the Money Laundering Act 2002, the governing words are here mentioned that proceed of crime means any property derived or obtained directly or indirectly by person as a result of criminal activities in relation to the schedule offence. Right. So thumb rule is schedule offence.
Right.
No, this is the added matter, because like basically schedule offence will continue and property will be attached under the Benami property or under the PMLA, so that the person is prosecuted, the property will go to the government. That was the thing. No, the point is here basically the dilemma is that one side this provision is there read with section 5, where section 5 is also says attachment section is schedule offence. But on the other hand, when the amendments are there after the about 5-6 years back, there are so many amendments which is sub judice before the larger bench of the Supreme Court. Now basically their case is, there are two views. The agency view is that it is a standalone act. And the other view is that it cannot be standalone because it is attached with the schedule offence. If the schedule offence will go, everything will go. Because this action is taken on the basis of the schedule offence. So section 5 of the act, I will just read one line which basically throw light that section 5, why basically how the action is initiated by the authority. Now section 5 says that attachment of property involved in money laundering, where the director or any director not below the rank of deputy director authorized by the director for purpose of this section has reason to believe in writing on the basis of the material in his possession, any person is in possession of any proceed of crime, number one. Right. Number two, such pursuit of crime are likely to be concealed. And proviso says so. So there are two things. One is that somebody has got the possession of the pursuit of crime. The second point is that there is apprehension that he will conceal it. Ultimately, suppose the trial is over, he may conceal it, he will eat, he may be having the gambling or so many things, he may put the money in the share market. So basically, if somebody has got the doubt that he has the pursuit of crime, he may conceal it. Therefore, basically, the officer has empower to take the action. Then there is a proviso. There is a proviso, that is exception, provided that no such order of attachment shall be made unless the complaint has been filed or any report under section 173 of CRPC before the magistrate. Now the point is, there are two things. One is basically action can be taken by the officer. Either some complaint is filed or some charge sheet is there before the magistrate under section 173.
Which will be under the scheduled offence.
Under the schedule offence.
Okay.
Before the appropriate court.
And a scheduled offence can be like the Indian Penal Code, or it could be like
procedure is Criminal Procedure Code.
And Criminal Procedure Code, or it could be even the NDPS, which is like the drugs law. So these are the categories that get covered under the scheduled offence, or even the Prevention of Corruption Act. So if anybody who is involved in
these are the respectively scheduled offences.
So in a sense, that's the crime that we're talking about, and the proceeds of that crime are what are covered by PMLA. So that's proceeds of crime.
Some basically security is given, right, so that he may not eat the money. Property means movable property or immovable property. So that basically somebody has played a fraud upon the state, or somebody has cheated the state with the pursuit of crime. If it is proved that it is a pursuit of crime, money should not go to him. Right. It should not be in the hand of the offender, or which is earned in criminal activities. Right. So these are the things. Basically.
So which is what the name also suggests for our viewers. The name is Prevention of Money Laundering Act. What is money laundering? In the simplest of terms, it is conversion of proceeds of crime or illegally earned money or other property into what could be property or money with a legitimate origin. In simpler words, in household words, if we say converting black money or illegal money or property into white, or that's how we talk about it. So sir, you've mentioned proceeds of crime a lot of times. If you could elaborate a bit more on that.
I will just give the example. I have just read pursuit of crime, definition of pursuit of crime, section 2B, that if somebody has earned the money by criminal activities and drive the money, and somebody is involved in there, and some second party has got the conspiracy with the main accused, that is a pursuit of crime. I will just give you an example. Suppose A takes loan from the B bank. So he doesn't pay the money to the bank. In installment does not pay, not returning the money to the bank. That is a simple case of recovery of money by the bank in a civil matter or criminal matter, no problem at all. Because it is not a pursuit of crime, frankly speaking. Now, basically, second scenario is that A has taken the money from the bank under the pretext that he will have some small business. And he divert the money. He does not spend the money for small scale industry, but he spend the money in share market, or he basically gambles it. He goes to the casino and he is spending the money. It means that he has cheated the bank. There is an agreement between the bank, that is lender and borrower. He has made the wrong statement before the bank. Then it is a case of 420, because he has taken the money, and he taken the money under the condition that he will spend for some particular purposes. That is also not pursuit of crime. That is basically maximum bank can file the suit against him. Bank can basically file the criminal complaint against 420 or something, cheating or something like that. But suppose third scenario is, suppose somebody goes to the bank. He says that you give me money, 100 rupees loan. Bank says, all right, where is the security? He mortgage the security to the bank, And he says, here is a security of 100 rupees. You give me 100 rupees. And ultimately, he takes the money. He doesn't pay the installment. He doesn't return the money to the bank. And ultimately, bank found that basically the mortgage property is not the genuine mortgage. He has already mortgaged the property with some other bank.
Okay.
So basically, the bank says that you have taken the loan under the pretext of mortgaging the property, and second, basically, these mortgage deeds are forged and bogus documents. You have already mortgaged with such and such bank, and now you have taken the money, and you have not even spending the money for the same purposes. You are spending the money for different purposes. For drug purposes, you are purchasing the drug and you are smuggling the things. So basically, then it is a case of money laundering. It is a pursuit of crime. That basically pursuit of crime, and the supposed pursuit of crime is lying with a particular person, and he has some other friends or associate where there is a conspiracy between two persons. Money does not go to him. He has not gone to the bank, but this person is involved with him. Then he basically transfer the money to him also. So that money will also basically, because it has traveled to the B, right. So that is also pursuit of crime. His property will also be attached, right. And then basically B basically transfer the money to C.
So
he takes the money.
It's so part of a chain of conspiracy.
It's a total chain. So wherever the money will go, money will basically travel. So it will go to the pursuit of crime. But on the other hand, suppose it does not happen. Then basically, suppose somebody just go to the bank, he says, give me the money, and basically money is taken, and he has lost the money, business is not clicked, COVID is there, some special circumstances are there, he has lost the business, and he did not pay the money to the bank in installment, or he is not returning the money. Then question of money laundering does not arise. Yeah. He has to return the money. Yeah. The bank can recover in various mode. Even law says that if somebody is unable to pay the bank money, maximum basically he can go to jail for 6 months. Right. Because it is the hard luck of the bank not able to recover the money. Right. So that is not the pursuit of crime.
So when we talk about PMLA proceedings, or the PMLA law, is it a standalone law? Or is it always dependent on scheduled offences? Because there's a lot of debate on this because the ED, the Enforcement Directorate, which is the prime prosecuting agency under this particular act, it has been asserting, in fact, it did so in recently also in the Supreme Court, that this is a standalone law. So what can you just, explain a little bit about on this debate and what the issue is all?
Actually, I mentioned to you that it is a revolutionary act. When originally came, when the initiation was taken by the ED, I say, now position is totally changed. The point is, there are so many amendments, and if we read the amendment very carefully, it appears that it is a standalone. Okay. Because in every section or rule, they say in this act, under this act, in this act. Okay. So if basically one will say, all right, if somebody will read, it will look like standalone. But at the same time, because the main section says schedule offense, like schedule, I have read section 2U and section 5 also, which says schedule offense. If basically schedule offense will go, everything will go. That is basically if we read section 2, section 5 and 8. So this issue has to be dealt with. It goes from time to time to the High Court and to the Supreme Court, High Court. So many judgments are there, but they basically after the judgment they immediately amend the act. Amendments are there. No, the point is basically it's a very larger issue, because unless basically these two sections are amended and totally schedule offense is revoked, simply basically deleted, that irrespective of schedule offense, so it is a standalone act, then basically you are right. But otherwise this confusion will continue even in the High Court or before the Supreme Court. because section says that the base is schedule offence.
You said a very interesting thing. You said that it was introduced as a very strong law, but then it has evolved since then. Its character has changed. Now, just for our viewers, the Act itself is a child of not just one government. There has been criticism. It was introduced by the Vajpayee government, passed by the Vajpayee government in 2002, but it was implemented. The rules were framed under the Manmohan Singh government, and 2005 was when it became, it was implemented finally, and then it has sort of gone through a trajectory. Now, you mentioned amendments. I would like to bring about section 45, which has gone through its own trajectory with the law. It was the twin conditions of bail was struck down by the Supreme Court 2017, then 2018 it was amended, and now the Supreme Court has upheld those conditions. If you could talk a bit about that trajectory generally.
Just to add one thing over here, sir, in fact, section 45 has been quite debatable because, they were termed as restrictive provisions of the law,
right.
And that was one of the reasons why the Supreme Court in 2017 struck it down. So while you are just talking about the amendment part in the law, if you could just also reflect a little bit on whether this law overall is actually a restrictive law or not, sir.
I'm telling you, when this act came before the Vajpayee, then basically another government A and government B, there was nobody was invoking section 45, or they are not interested.
There was no
they go for schedule offence.
Okay.
They always say bail is granted.
Okay.
Now, even basically till 14 and 15, there is hardly any basically invocation of section 45. And one thing further I tell you, you will surprise, that the agency is not arresting the accused party in every case. They are only basically exercising this empowerment only in 2% cases or 3% cases. I will not say why, against whom basically it doesn't look nice, because I am not a politician. No, the point is basically the earlier basically only 2-3 years back, till they were taking 45 very casually, because schedule offence, if somebody will go get the bail, nobody will touch it. Now, after this amendments, so many amendments, when they say in this act, under this act, no, they claim themselves as the standalone act.
Okay.
That's the 2018 amendment.
This question came up before the Supreme Court, before Justice Rohinton Nariman and Justice Sanjay Kishan Kaul. So they felt that basically this is not proper, because the base of the act is schedule offence. They say it will apply, same tool will apply. PMLA Act section 45 is equivalent to general provision section 438 and 439 of CRPC for bail. No, basically
the principle should be the same for grant of bail. Yeah.
But immediately amendment was done. Two conditions were put. Somebody welcome it. One set of people, another set, they said why basically it should be done. Somebody even basically, one of the argument, because I've heard so many senior advocates during my tenure, they say that basically they will claim that there are 2 bail applications rather 1 application, and it has actually happened. Because one has to go twice.
First under the scheduled offence and then again under the...
You will surprise that they go before the different courts. One goes to Supreme Court and another goes to Allahabad High Court, or one. So different 2 judges' view mind are there. Because one is granted the bail, suppose Supreme Court is like latest in case Kapan.
The Siddiqui Kapan case,
So Supreme Court has granted it, but Allahabad High Court says that
he was granted bail under the scheduled offence, which was under the Indian Penal Code.
Yes.
And but under the PMLA offence, which is being investigated by the Enforcement Directorate, the special ED court has actually rejected it.
No, the point is twin conditions are there. The first condition is that the senior officer, law officer, should be heard during the bail arguments. The second condition is that the court must come to the prima facie view that this person is not involved in money laundering. So then you grant the bail, otherwise you cannot grant. No, the point here is this is different than the bail application under the schedule offence. As far as argument of the government officer is concerned, nobody is raising any objection. They say, all right, any party, they say, argue, that's all, whether Attorney General or Solicitor General or Additional Solicitor, whosoever is arguing, people are welcoming it, no problem at all. But the second condition is that the court must basically give the finding, court must read all the papers while hearing the bail application and come to the conclusion that basically this person is not involved in money laundering. So there are so many seminars, judicial academy, where judges are protesting. Some of the judges, they say basically, if we have to decide this thing, why not quash the proceeding? Why we should decide the bail application? I say this point will not help anybody. Because suppose one of the judge says, yes, I am granting the bail, I have heard the government official, I have gone through the material, and I feel that no case is made out, it is not a case of money laundering, therefore I am granting the bail. No, basically this evidence exercise would be there for 10 years, and 10 years, 100 witness would be there, 50 witnesses there, and after 50, all the long exercise, after spending lot of money by the government, after spending lot of money by the private party, and the judge has a order in his order which is written that he is not involved in money laundering, so he has to change his opinion.
True.
So it will not help anybody.
True.
I say simply, basically, bail application should be decided on merit. Whether basically he is involved in schedule offence, whether he is such a offender. In this matter, bail should not be granted under the PMLA. It should not be granted. But the point is, if you put the condition, therefore, my view is that the view taken by in 17 was the correct view. But now the Supreme Court in recent judgment has set aside that judgment. That is overruled that judgment. So, but I am telling you, it will not stop here. It will continue. This debate will continue in the High Court. This debate will continue in the Supreme Court. Because the point is, the frame of the act is such. Because there are so many contradiction sections, there are so many contradiction rules, there are so many contradiction amendments. Suppose on the basis of the judgment, on the basis of some order passed by a High Court, you amend the act or you bring the more exception, it will not help, because one of the court, whether High Court or Supreme Court, will see everything from every angle. Then basically, you know what has happened to Tada and Farah, you know, they quash everything. So I want, when this act is a revolutionary act, why not basically we should exercise the discretion against the genuine person, whosoever is involved, because this is my country also, this is your country also. Nobody wants that the person who is involved in money laundering should go escort free. But the point is basically, the point is only application of law.
Right. That's where you think there needs
Act
to be
is revolutionary, everything is good. But how to apply, somebody will apply his mind. If somebody will say, if the judge will say, yes, he is not involved in money laundering, then how can he change his opinion after 10 years or 20 years?
So basically, of late, the criticism which has come against invoking the law is that, you know, it's the process which is becoming a punishment rather than the law itself, you know, in the sense that we are really not able to achieve the objective of the law, but by invoking this law against all and sundry, what we are really trying to do is just trying to, you know, keep them behind the bars. So this is the main criticism which this act, I think so, is today facing, because we are seeing that, you know, it is rampantly being used by the Enforcement Directorate. Now, the moot question is that whether these prosecutions actually end in acquittal or not, whether the investigation undertaken under this law really, sees a final result or not, and what is the rate of acquittal and conviction in this?
I'm telling you, I totally agree with you on all the points. I agree with you that process is harming the innocent people, because on the basis of the presumption, if you do something without FIR, without charge sheet, without any serving document, and then basically you take the person to that extent that it is a standalone act, and process will kill him because his goodwill and reputation will also be ruined by that time, because the media is also very much concerned about the PMLA and other allied acts. So I say that either basically the action, there are 2-3 points. Number one, that either you initiate the proceeding only against the genuine person, then somebody may not have any grievance. But if you are taking the action on the basis of the presumption that I presume you don't have the FIR, no money was recovered, you don't have any case, you don't have any charge sheet, and then basically, but we presume that you may be having some presumption and having some connection with A who is involved. Then basically this procedure, basically because B is suffering, C is suffering, D is suffering, some formula should be there, some amendment should be there, that the trial must be finished within 6 months or within 1 year. Otherwise the purpose will be totally defeated, and you will surprise that most of the cases at this moment there are about 5,000 cases pending. Only God can decide, because all the tribunals, 6-7 tribunals are in one tribunal, because Benami was the different tribunal, FEMA was the different tribunal, because it has come in one tribunal. Humanly it is not possible. You know, I was working 16 to 18 hours every day in PMLA. Still basically sometime I was not able to give maximum disposal. So now basically 6,000 cases are there. And you know, the trial, CBI trial and ED trial, there are too much big record, thousands of cases. In CBI cases, 10,000 cases, 15,000 cases, witnesses are 200 witnesses, 100. Only basically God can examine all the 200 witnesses in 2 years time or 3 years time. You must have the focus on proceed of crime, and you should catch only genuine person. Then basically it can be a very successful act. It will be a revolution and people will praise everything. But basically if everything is jumbled up, messed up, then there is a problem. Then basically, you know, the trial may take, you see the trial and how many cases are decided, less than 1% conviction is there. Whatever I am reading, whatever is my record, and whatever basically is being printed, I have heard, and actually less than 1%, and there is hardly any trial completed. You say end. And even God knows, I am telling you. And I don't see end. End is basically only when basically genuine cases are filed. If somebody is sincere, he will examine everything. One officer should be there and he should decide the action should be filed against A, action should not be filed against B, action should be filed in C, action should not be filed against the D. So unless basically this monetary system should be there, nobody, because suppose you are keep on filing the cases, you know, in the Act, second proviso of Section 5, you will see there is a bar. Section 1, first proviso says that no complaint, no proceeding can be initiated unless complaint is there or a report 173. But second proviso now added after few judgment by the High Court and Supreme Court, which says it can be there. I totally agree. They say only in emergency cases where the urgency is there. Suppose somebody is taking the money from the bank and somebody has the ticket in their pocket, or somebody is having the agreement executed by selling the property, he has the money laundering proceed of crime and he is basically selling the property, and then basically he is running away from India. Then basically in those circumstances, because second proviso says only in emergency cases. So it should apply basically in emergency cases where basically FIR is not there, or proceed of crime, this charge sheet is not there. Only in those cases it should be applied. Otherwise, major cases should be where the charge sheet is there as well as some complaint is there.
So, just a last pointer here, since you mentioned that, it was a revolutionary law, we've spoken about it, but you're saying that only genuine cases should be filed. What do you think will help? Does it need parliamentary interference in the form of amendments? Does it need more curbs on the enforcement agencies? Or does it need all of this
I
to
will
become...
give you 2 examples.
Yeah.
I'm telling you because in 3 years I have noticed that the bank has given the loan where basically money laundering cases are pending worth 5 lakh crore or 10 lakh crore. Against the loan, they have got minimum security. Security of mortgage of properties. Now, the general law is that bank gives the money. Bank is a lender. Money who has taken is the borrower. Now, basically, there is an agreement between the parties, and borrower has to pay in installment or lump sum, whatever. Basically, suppose it doesn't pay, what is the next course of the bank? To give the notice or file the FIR that he is not giving the money because there is an agreement. We can take civil or criminal action. Now, the point here is basically when basically mortgage property they are going to sell it on the basis of the bank FIR. The cases are registered by the agency, ED. Okay. They say, and they attach the same property. The property is attached, it means that you are ruining yourself. You are basically blocking the money of the bank. Right. So they are not attaching other than those properties, mortgage properties. Only basically bank property is being attached. And then basically attachment will continue for years together. Who is the beneficiary? Beneficiary is borrowers. Because their property is safe. They are not paying the money. Then basically other tribunal is there, IBC tribunal. No, that basically non-performing company is there. Then they apply there, and 1,000 crore property is being sold for 100 crores. So bank will not get. And who is purchasing the property?
Somebody
Friends,
known to the
associate.
borrower. Yeah.
And then who is the sufferer? Bank is the sufferer. Bank is having the public money. And suppose bank is suffering, public is suffering, then the state is suffering. My formula is totally clear. When I was there, I say that the bank money should come immediately. And whosoever is playing, because in some of the cases I have noticed that even basically lenders who are very big companies, I will not name those companies, who are claiming themselves within 10 companies or 100 companies. They because I have got the complaint that they themselves are filing the complaint through somebody and attaching their property. And they are, I say that my first question always before the tribunal is that if you have taken the bank money, why you are not returning it? They take the money, they divert the money to the company B, and then basically then the agency says give the money. They don't give. Bank says give the money. They are taking the shelter of the company law. They say because the company is there, directors are not responsible to pay the money. Directors are living in 7-star hotel house, and their children are basically studying in outside. And I say each and every person, one should be very fair. Whosoever taken the loan, whosoever taken the money, he must return. Otherwise, he should not be allowed to go outside. Their children should not read. Even basically the person who is earning hard, he's paying the taxes. But now basically you are diverting the money and you are taking the shelter because it is a different company. You cannot recover it.
So what you're trying to say, sir, here is that the prosecuting agency should be more focused when it comes to investigating these kind of cases. There should be pinpointed allegations. The charges should be very specific so that there is no beating around the bush by the accused.
This is a real point I am telling you. I will just give the example, then I think time is over. Because 30 to 40% cases before under the PMLA Act is of civil nature. Suppose somebody has got the property in defense colony, and then basically he is selling the property. He intends to sell the property. He has the agreement with B, some builder, and B gives him 1 lakh rupees. There is a agreement. There is a clause in the agreement. The remaining payment will be made within 6 months. Otherwise, your 1 lakh will be forfeited. That is a general principle in the entire world. No, he doesn't give in 6 months. there is a notice by the advocate that you return because you have mentioned that you will pay, otherwise we will forfeit your money.
Right.
Builder does not give the reply, and basically the moment he refuses and the property owner says that we will not sell the property because the time is over, your money is forfeited, the limitations start from that date. 3 years builder can file the suit for specific performance. But many cases I have noticed that this transaction was done in 15 years.
But they are coming
Even
to
1 day cannot be condoned by the Supreme Court, by the High Court.
under the civil law.
But they filed a complaint and they got the attached property of the old person, old citizen.
They are filing complaints under PMLA.
PMLA.
So which means there is a lot of misuse of the law, which is that is also
this
happening.
misuse should not be allowed.
Right.
Because many cases are of civil nature, recovery nature.
That are going to the PMLA.
PMLA should not come. Only focus should be that whosoever is involved in economic offender, he is an economic offender, that person should not be. Because you will be having a very less cases. Only focus would be only on offenders. Now, basically, if you bring the PMLA in the general law, only God can help it. That was my answer.
Right. With this, we've reached the end of today's discussion, and from what I get from this is that PMLA, which is Prevention of Money Laundering Act, began as a very breakthrough, as a very revolutionary idea to stop money laundering in the country. However, over the years, as Justice Manmohan also spoke about, the law has gone through a transformation parallelly through courts and through subsequent amendments. It is 2 aspects of the law are currently pending adjudication before the Supreme Court. The Supreme Court is reviewing its own judgment. But in the meantime, what we gather from this discussion is that a lot more can be done to the law so that there's a more streamlined implementation of the law, and so that the law can actually fulfill its final purpose, the purpose for which it was brought in 2002. I hope you enjoyed this episode. As I always say, please do let us know in the comment section what you think about this law, about this episode as well, about this video series. Do give us your suggestions, feedback, and if you have any law that you want to know more about, we'd be happy to take it up with one subject matter expert, Bhadra, and me. So do let us know, and keep following us on social media and supporting us the way you do. Thank you.